The U.S. Court of Appeals for the Second Circuit has approved of a preliminary injunction that would block the Trump administration from enforcing its newly adopted interpretation of what constitutes a public charge in U.S. immigration law. Why did the court decide the case this way? And what does it mean? Well, stay tuned, and I'll explain. My name is William Kovach, and I am a trained immigration lawyer. I've often been disappointed in the way immigration issues are talked about in the media, although it's not always their fault. Immigration law can be a very complex subject, touching upon constitutional issues as well as personal political points of view. My goal is to explain immigration law to you, concentrating on looking at judicial opinions and executive actions in order to explain how immigration law can have an impact on our community and on our country. I hope that you'll join me as we try to make sense of immigration law and how it may affect the average person. This is the second of 3 videos on the issue of public charge in U.S. immigration law. In the first video, we talked about how the term public charge has appeared in the U.S. immigration law as Congress has passed it. We talked about how the Trump administration adopted its interpretation of the law and announced how it was going to enforce the law in the future. In this video, we're going to address a recent decision by the Second Circuit, which approved the granting of a preliminary injunction that prevented the Trump administration from enforcing its new rule, and that decision was issued on August 4th, 2020. In the next video, we will discuss a diametrically opposed decision that was issued by the Fourth Circuit just 1 day later on August 5th, 2020. So let's start with just a little bit of background. When the Trump administration announced its new rule back in 2019, a number of parties filed suit in the U.S. district courts across the country, and the U.S. district courts are the trial-level courts in the federal system. Now, many of the district courts issued preliminary injunction, and those are orders from the court that meant to maintain things the way they are, preventing the Trump administration from enforcing a new rule until the trial court could hold a hearing. But the government appealed those decisions to the U.S. Courts of Appeal, and they asked for something that's called a stay. Now, a stay is just a court order that prevents the preliminary injunction from taking effect. Let's take a step back and discuss the structure of the appellate courts. The U.S. Courts of Appeals are divided into 13 circuits. 12 of those circuits are based on certain regions of the country and can hear appeals from the different district courts. A number of the circuit courts denied the government's request for a stay. So the government responded by going up one more level to the highest court in the federal system, and that is the U.S. Supreme Court. And on January 27, 2020, the U.S. Supreme Court issued an order granting the stay, and this meant that the preliminary injunctions would not go into effect. What is striking, however, is just how little the Supreme Court said in that order. This is a copy of the stay that was issued by the Supreme Court. It's in the case of the Department of Homeland Security versus New York. The stay was issued on January 27, 2020. The application for stay presented to Justice Ginsburg and by her referred to the court is granted, and the district court's October 11, 2019 orders granting a preliminary injunction are stayed pending disposition of the government's appeal in the United States Court of Appeals for the Second Circuit and disposition of the government's petition for a writ of certiorari, if such writ is timely sought. Should the petition for a writ of certiorari be denied, this stay shall terminate automatically. In the event the petition for a writ of certiorari is granted, the stay shall terminate upon sending down the judgment of this court. We know that Justices Ginsburg, Breyer, Sotomayor, and Kagan did not agree with issuing the stay. There was also a concurring opinion from Justice Gorsuch, in which Justice Thomas joined. In his concurring opinion, Justice Gorsuch basically voiced his disagreement with this trend of U.S. courts issuing nationwide preliminary injunctions. So Justice Gorsuch has already gone over the state of the litigation nationwide, and he states, if all of this is confusing, don't worry, because none of it matters much at this point. Despite the fluid state of things, some interim wins for the government over here, some preliminary relief for plaintiffs over there, we now have an injunction to rule them all, the one before us, in which a single judge in New York enjoined the government from applying the new definition to anyone without regard to geography or participation in this or any other lawsuit. The real problem here is the increasingly common practice of trial courts ordering relief that transcends the cases before them. Whether framed as injunctions of nationwide, universal, or cosmic scope, these orders share the same basic flaw. They direct how the defendant must act towards persons who are not parties to the case. I concur in the court's decision to issue a stay, but I hope, too, that we might, at an appropriate juncture, take up some of the underlying equitable and constitutional questions raised by the rise of nationwide injunctions. So now we're in the litigation after the Supreme Court granted its stay, and I know this can get confusing, but the district courts still get the opportunity to hold their full trial to determine whether or not the Trump administration's interpretation was legal. But because the stay is in effect from the Supreme Court, even though all of this litigation continues, the district court's preliminary injunctions are still not effective. So for now, the Trump administration can enforce its public charge rule. So even though the Second Circuit's opinion was issued after the Supreme Court stay, meaning that even though it approved of the preliminary injunction, that injunction still will not take effect, the litigation is still important. The Second Circuit's opinion is going to give the Supreme Court one perspective of how it could decide the case. In fact, in order to overturn the Second Circuit's argument, the Supreme Court will have to address its reasoning. The Second Circuit's decision could even be persuasive to some of the justices that sit on the Supreme Court, and it could wind up being the way that the majority of the court eventually decides the whole case. We'll have to see. So without any further ado, let's get to the Second Circuit's decision. So the facts and history of both the Second Circuit case and the Fourth Circuit case are basically the same, so I'm not going to go into any details about them here. Now, there are also some issues in these decisions, such as standing, and for the sake of brevity and keeping this easy to understand, we're just going to concentrate on how the courts analyzed the public charge rule itself. So we're in the Second Circuit. This is the case of the state of New York versus the Department of Homeland Security. And a reminder that the Second Circuit addresses case coming out of New York, Connecticut, and Vermont. In a statutory construction case, the beginning point must be the language of the statute. If the statute text is ambiguous, we also examine canons of statutory construction to identify congressional intent. Here, the plaintiffs do not argue that public charge is unambiguous on its face, relying instead on the ratification canon to ascertain the clear intent of Congress. So what we have here is basically the first part of the Chevron analysis. And if you saw the first video on the public charge rule, you know that we have this case called Chevron that establishes the rule of how we analyze an interpretation of a statute from Congress. And the first part of the Chevron analysis looks to the text of the statute itself. Is the text clear? Is the language used unambiguous, meaning that it can only have one meaning? The ratification canon provides that Congress is presumed to be aware of an administrative or judicial interpretation of a statute and to adopt that interpretation when it reenacts a statute without change. The plaintiffs argue that Congress ratified the settled judicial and administrative interpretations of public charge as it repeatedly enacted the public charge ground over the course of more than a century, most recently in 1996, such that the current public charge statute unambiguously forecloses the rule's new interpretation of the term. So first we have a summary of the plaintiff's arguments, and the plaintiff's arguments is somewhat nuanced. Now remember, we're in the first step of the Chevron analysis. That first step is the text clear and unambiguous? And what the plaintiffs are saying is not so much that the words public charge are themselves so clear that there can't possibly be any other meaning. What they're arguing is that Congress knew how the INS, which was interpreting public charge way back in 1996, that was the last time Congress passed the statute. And Congress is presumed to know how the agency interprets the words in its statute. So if Congress knew how INS was interpreting the words public charge, and Congress reenacts the statute using the very same words, then it's presumed that public charge is going to have the same meaning as it was interpreted before Congress reenacted the law. In response, DHS argues that its interpretation is not precluded by the historical interpretations of public charge, and that other provisions of the INA show that the rule is consistent with Congress's intended meaning of public charge. Proper application of the ratification canon requires a thorough understanding of the evolution of the public charge statute from its inception in 1882 to its enactment in its current form in 1996, as well as the accompanying body of administrative and judicial decisions interpreting the term. Accordingly, we begin with a historical review. So now we see that the government is countering by arguing that the words public charge is not as limited as the plaintiffs are representing, that these words were left without a definition, and that they're broad enough to include the definition that the Department of Homeland Security has adopted. And the court is saying, well, we need to look at all of this. We're going to look at the whole history of the words public charge. And they're going all the way back to the first time that Congress used the words public charge, which was in the statute in 1882. The public charge ground has its roots in concerns that arose in the late 19th century that foreign nations were addressing poverty within their own borders by funding passage to the United States for their poorer citizens. As one of the primary immigrant-receiving states, New York in particular was concerned that, upon arrival, these non-citizens became at once a public charge, getting into our poorhouses and almhouses. In response to the costs of supporting new arrivals and other expenditures associated with its role overseeing the immigration process, New York attempted to impose various taxes and bonds on arriving immigrants as well as the shipping companies providing their transport. The Supreme Court, however, repeatedly struck down these state statutes as unconstitutional on the grounds that the Constitution vested the power to regulate with foreign nations in Congress. New York thus turned to Congress for assistance, lobbying for the enactment of two provisions that ultimately became law with the Immigration Act of 1882, the public charge ground of exclusion and the immigrant fund. The inaugural public charge statute directs immigration inspectors to board arriving ships and refuse permission to land to any passenger who is unable to take care of himself or herself without becoming a public charge. So as I said before, what's happening here is that the Second Circuit is going all the way back to the first time that those words, public charge, were used in U.S. immigration law. And it's saying even though Congress meant to exclude people who couldn't care for themselves, it didn't mean to exclude those people who were just down on their luck and needed some temporary help. So the term public charge can't mean that the receipt of benefits alone could make somebody a public charge. And that's because back in 1882, Congress set up a system. They set up a benefit where people, immigrants who needed help, could apply for that help temporarily and get a benefit from the federal government. If Congress had meant that the receipt of benefits alone was enough to call somebody a public charge, it wouldn't have set up this system. And in this way, the Second Circuit is trying to undermine the ability of the Department of Homeland Security to define public charge based solely on the receipt of public benefits. While denying entry to those who could not care for themselves, the Act simultaneously established an immigrant fund, which was to be used, among other things, for the care of immigrants arriving in the United States and for the relief of such as are in distress. By these provisions, the Act established a scheme that distinguished between those arriving immigrants who were unable to care for themselves and those who were merely in distress. So the court is emphasizing again that through history, public charge has meant more than just being poor or not having any money. The Second Circuit even looked at a Supreme Court case from the early 20th century where the Supreme Court was looking for something more than just being poor. They were looking for some sort of permanent condition that would prevent somebody from supporting themselves. So now the Second Circuit's going to go more into the history of the statutes that were passed by Congress. We're going to skip ahead now to the Immigration and Nationality Act of 1952, also known as the INA. And this is the core of the statute that's still in effect today. There have been amendments to the INA, but the INA itself is still the basic structure of U.S. immigration law. And specifically, what the court's going to look at is what was the intent of Congress when it passed the INA. And when we're looking at congressional intent, you have a committee that considers a bill and then recommends whether or not to pass the bill to either the full House of Representatives or the full Senate. In doing so, that committee will write up a report. The report will explain the bill, what is the intention of the bill, and why certain language is being used. Here, the Second Circuit is going to be looking at a report from the Senate Judiciary Committee on the 1952 INA. Early interpretations of the term public charge from this era come principally from state courts and treat the term as somewhat interchangeable with pauper, distinguishable from those who were simply poor by the permanence of the condition. For example, the Massachusetts Supreme Court explained that a bond could be required for arriving immigrants who had been paupers in a foreign land, that is, for those who have been a public charge in another country, and not merely destitute persons who, on their arrival here, have no visible means of support. The court affirmed that the bond was necessary only from those who, by reason of some permanent disability, are unable to maintain themselves and who might become a heavy and long-continued charge to the city, town, or state in this country. So now the court is looking at the latest changes in the law, and they came from acts passed by Congress in 1996 that amended the INA. And remember, the structure of the INA stayed in place. These were just some changes to that structure. In fact, all Congress did was add criteria that it wanted INS to consider and add a requirement that an immigrant find a sponsor. The Judiciary Committee report devotes several pages in a review of the public charge ground. The report notes that courts have given varied definition of the phrase likely to become a public charge, but summarizes the case law as focusing on 4 characteristics that indicate non-citizens are likely to become public charges. 1. Impending or current imprisonment in federal prison. 2. Limited finances. 3. A weakened physical condition as it relates to his ability and capacity for employment. And 4. Traveling to the United States on a ticket paid by someone else. The Judiciary Committee recommended that the public charge ground be reenacted in the forthcoming INA and further recommended that the term not be defined in the statute since the elements constituting likelihood of becoming a public charge are varied. Administrative interpretations of public charge after the enactment of the INA largely align with the pre-1952 interpretations. In 1964, the Attorney General noted that the term had been the subject of extensive judicial interpretation and that the general tenor of the case law understood public charge to require some specific circumstance such as mental or physical disability, advanced age, or other fact reasonably tending to show that the burden of supporting an alien is likely to be cast on the public. The point here is that Congress considered making the receipt of certain means-tested benefits a factor in determining whether a person is a public charge, but they ultimately rejected the idea. And think about the politics of the time. Back in 1994, it was the first time in 40 years that the Republicans captured the House of Representatives. So we had the House of Representatives that was controlled by the Republicans, but we also had the president, who was Bill Clinton, a Democrat. And in order to pass these changes to the immigration law, the Congress had to consider that Bill Clinton could veto the changes. So they had to negotiate with Bill Clinton and come up with a compromise that both parties could be happy with. So, with that background, Congress rejected the idea of including in the statute considering certain public benefits as meaning that a person was a public charge. The point being that if Congress rejected the idea in passing the latest version of the legislation, then how can the government now adopt an interpretation that does the same exact thing? That is, how can it adopt an interpretation of the law when that approach was specifically rejected by Congress? There can be no dispute that since its origins in the Immigration Act of 1882, Congress reenacted the public charge ground without pertinent change in 1891, 1907, 1917, 1952, and 1996. We note that Congress made minor alterations to the ground over the course of its history. But Congress has unwaveringly described the fundamental characteristic at issue as being a public charge since 1882. Our review of the historical, administrative, and judicial interpretations of the grounds over the years leaves us convinced that there was a settled meaning of public charge well before Congress enacted IRA. The absolute bulk of the case law from the Supreme Court, the Circuit Courts, and the BIA interprets public charge to mean a person who is unable to support herself either through work, savings, or family ties. Indeed, we think this interpretation was established early enough that it was ratified by Congress in the INA of 1952, but the subsequent and consistent administrative interpretations of the term from the 1960s and 1970s remove any doubt that it was adopted by Congress in IRA. Congress intended the public charge ground of inadmissibility to apply to those non-citizens who were likely to be unable to support themselves in the future and to rely on the government for subsistence. So the Second Circuit has reached the conclusion that the words public charge, as used in the statute, are themselves clear and can only have this one meaning. Now, personally, I disagree with this approach, and I think many of the other circuit courts would probably agree with my position. And that's because in the step 1 of the Chevron analysis, we're looking just at the text of the statute itself. Is the text of the statute so clear that it can only have this one definition? I think much of what the Second Circuit was looking at really goes to that second step of the Chevron analysis, and that is whether the interpretation adopted by the government is a permissible one. And that's where we're supposed to look at legislative intent to see if the interpretation conflicts with the intent behind the legislation. And first, I think the Second Circuit is basically daring the Supreme Court. You need to reject this argument if you're going to find for the government. I also think the Second Circuit knows that if its argument is correct, then that means that these words, public charge, can't be interpreted in any other way. That is, it's foreclosing the ability of another administration to try exactly what the Trump administration is trying here. But of course, since we now have circuit courts that have different opinions on this, and that's called a split in the circuit. Now that we have a split in the circuit, it's going to be up to the Supreme Court to settle the matter and decide which rule is going to apply. We think it plain on the face of these different interpretations that the rule falls outside the statutory bounds marked out by Congress. Our conclusion is bolstered by the fact that many of the benefits newly considered by the rule have relatively generous eligibility criteria and are designed to provide supplemental assistance to those living well above the poverty level, as we discuss in greater detail below. So no surprise, the Second Circuit has found here that the rule adopted by the DHS is inconsistent with the meaning of public charge as used in the statute. And of particular concern for the Second Circuit is that the criteria of some of these benefits are somewhat generous. And that is, you don't really need to have some permanent issue that makes you unable to support yourself. These programs are available if, for example, you just have a temporary setback, or because the government has a broader goal, such as supporting greater nutrition. So now we're going to turn to an alternative basis for the court's action. Was the rule arbitrary and capricious? We next discuss whether the plaintiffs are likely to succeed on the merits of their argument that the rule is arbitrary and capricious. When an administrative agency sets policies, it must provide a reasoned explanation for its actions. This is not a high bar, but it is an unwavering one. Okay, so why is the court doing this? Haven't the plaintiffs already won? Well, yes, but we're expecting some serious litigation on this. So the court is basically saying, if we're wrong on that first point, we still have this second point to fall back on. And the question here concerns a change in interpretation. That is, where you have a statute where Congress is leaving it up to the administration to make certain definitions or to fill in the gaps. Well, you can have one administration interpret it one way, and then that doesn't necessarily lock future administrations into following that interpretation. You can have a change in statutory interpretation or a change in policy. It's just that there's a requirement that if you change the way you interpret a statute of Congress, that the administrative agency must offer a reasoned explanation. Otherwise, the change is going to be found to be arbitrary and capricious. And again, the Second Circuit is looking at how Congress considered back in 1996 and then rejected the idea that public charge could be defined by the receipt of certain benefits from federal programs. Had Congress thought that any benefits use was incompatible with self-sufficiency, it could have said so, either by making non-citizens ineligible for all such benefits or by making those who did receive them inadmissible. But it did not. Where, as here, DHS anchors its decision to change its interpretation in the perceived shortcomings of the prior interpretation and then fails to identify any actual defect, it has not provided a reasoned explanation for its actions, particularly when it bases its changed position on its reading of a statute, and it is the new rule rather than the old guidance that strays from congressional intent. So the court is looking at the government's explanation for why it changed its interpretation. And it's saying, look, you can't just claim that your new interpretation is superior to the old one, but then the interpretation you adopt is inconsistent with all of this evidence that we reviewed on what Congress thought about this idea of defining public charge based on the receipt of these types of benefits. So you may recall that one of the main differences between the rule that DHS adopted in 2019 and the rule that the INS adopted in 1999 was that the 1999 rule only considered cash benefits or long-term institutionalization at Medicaid expense. And DHS argued that this was proper because all of those other programs, such as Section 8 housing, food stamps, they all bear directly on whether a person is self-sufficient. So in these next few excerpts, the guidance that the court is talking about is that 1999 guidance that was issued by the INS. The guidance consequently excluded non-cash benefits, for example, SNAP, housing assistance, and Medicaid, from consideration because those benefits were increasingly being made available to families with incomes far above the poverty level, reflecting broad public policy decisions about improving general public health and nutrition. The fundamental flaw of this justification is while DHS repeatedly contends that non-citizens using these programs would be unable to provide for their basic necessities without government support, it does not provide any factual basis for this belief. While the 1999 guidance was developed in consultation with benefits granting agencies, DHS does not claim that their expertise informed their decision that people who use non-cash benefits would otherwise be unable to meet their basic needs. Of course, DHS is free to change its interpretation, and we do not suggest it is under any obligation to consult with its sister's agency in doing so. But what DHS may not do is rest its changed interpretation on unsupported speculation, particularly when its categorical assumptions run counter to the realities of the non-cash benefits at issue. The goals and eligibility criteria of these benefit programs belie DHS's assumption and show that these programs are designed to provide supplemental support rather than subsistence to a broad swath of the population, as INS recognized in 1999. Take, for example, SNAP. SNAP benefits are intended for all those whose financial resources are determined to be a substantial limiting factor in permitting them to obtain a more nutritious diet. Because SNAP is not intended for those who might otherwise face starvation, the program is open to households with incomes exceeding the poverty guideline, and its supplemental nature is underscored by the fact that the average SNAP recipient receives only $127 a month in benefits. Large numbers of SNAP recipients, far from being incapable of productive employment, work for some of America's largest companies. The housing benefits included in the rule have a similar aim, intended to ensure a decent home and a suitable living environment for all persons, but principally those of low and moderate incomes. Indeed, while the majority of those using housing programs are low-income families, benefits remain available to those earning up to 80% of the area median income, $85,350 for a family of 4 in New York City in 2019. It makes little sense to treat the mere receipt of housing benefits of proof of inability to survive by one's own efforts when the program is intended for, among others, people who can and do earn moderate incomes. In contrast, TAMF, one of the 3 benefits listed in the 1999 guidance, is generally only available to families with incomes well below the federal poverty guidelines. Okay, so what we got here is a compare and contrast. The court is basically saying that the benefits the government chose in the 2019 rule are just too broad. They're not benefits meant to be available only to the poor. In fact, they're available to a wider number of people, some of whom are very much self-sufficient. And again, all this goes to that reasoned explanation. The court concluding that the expansion of this rule to include all of these benefits that do not necessarily depend on whether a person is self-sufficient, that makes the proffered explanation, and that is that this is a superior measure to determine self-sufficiency, well, that's an unreasonable explanation. So finally, I want to talk about the scope of the remedy as adopted by the Second Circuit. While we hold the district court properly granted the plaintiff's preliminary injunction motions, there remains one final issue for our consideration: whether the district court abused its discretion by entering a nationwide injunction rather than a geographically limited measure. The issuance of nationwide injunctions has been the subject of increasing scrutiny in recent years, a topic that has already touched these cases on their brief foray to the Supreme Court. So you see that the court cited that concurring opinion by Justice Gorsuch that we discussed earlier. As the plaintiffs point out, Courts have long held that when an agency action is found unlawful under the APA, the ordinary result is that the rules are vacated, not that their application to the individual petitioners is prescribed. Moreover, courts have recognized that nationwide injunctions may be particularly appropriate in the immigration context, given the interest in a uniform immigration policy. On the other hand, we share DHS's concern that a district judge issuing a nationwide injunction may, in effect, override contrary decisions from co-equal and appellate courts, imposing its view of the law within the geographic jurisdiction of courts that have reached contrary conclusions. That result may well be more unseemly than the application of inconsistent interpretations of immigration law across the circuit, a situation that is hardly unusual and may well persist without injustice or intolerable disruption. When confronted with such a volatile litigation landscape, we encourage district courts to consider crafting preliminary injunctions that anticipate the possibility of conflict with other courts and provide for such a contingency. Such approaches could take the form of limiting language, providing that the injunction would not supersede contrary rulings of other courts, an invitation to the parties to return and request modification as the situation changes, or the limitation of the injunction to the situation of particular plaintiffs or to similarly situated persons within the geographic jurisdiction of the court. We need not decide whether the able district judge in these cases abused his discretion in entering nationwide injunctions. Instead, we exercise our own discretion in light of the divergent decisions that have emerged in our sister circuits since the district court entered its orders to modify the injunction, limiting it to the states of New York, Connecticut, and Vermont. So here you see that the Second Circuit is taking seriously the fact that these circuit courts are split up mostly regionally. And they're saying, keep in mind that when you have these multiple cases going on at the same time, it's kind of bad form for a trial court to overreach on an issue and have an injunction that could be inconsistent with a court from another region of the country. And they're adding, hey, look, the Supreme Court here has already stated the injunction. So, in a way, it doesn't really matter. Still, the Second Circuit here is exercising their discretion. So they're limiting their injunction to have effect only over the area that's covered by the Second Circuit's jurisdiction, and that's New York, Connecticut, and Vermont. So thank you for watching. If you enjoyed today's video, if you think you've learned something, please, by all means, give us a thumbs up and let us know in the comments below. Do you still have questions? Do you agree with the way the Second Circuit approached this issue? Are there other immigration decisions that maybe in the future you'd like us to discuss and explain? And thank you once again for tuning into our channel. Please consider subscribing. Thank you for watching. Please remember to like and subscribe. If there are any topics you would like me to address in the future, please let me know in the comments below. Now, I don't like talking about this, but I am currently disabled because of complications following cancer surgery. If you're feeling generous, I'll have a link to my PayPal account in the description below. Thank you.